One of the questions that individuals usually have about the Marchman Act is whether or not there can be any jail associated with this process. I'd like to first start out by saying that this is a civil process, not a criminal process. And so this is not about punishment, and this is not about getting someone into jail. Ultimately, though, there are times where someone's noncompliance exceeds even that expected by the family, and they're unwilling to follow the court's order. In that instance, the court has already ruled that an individual must be at or in a treatment facility, and they're non-compliant with a court's order can rise to the level of needing to be held in contempt. So there's a process that can be filed with the court to notify the court of this non-compliance with a legal court order, and then a process to hold them in contempt. In those instances, if an individual is so resistant to re-engaging and following that court's order, then the court is authorized to grant an order for their arrest and incarceration, which could last for up to 6 months. That's never our goal. And there's always the opportunity for that individual to come back out of jail and into treatment. In fact, regardless of how long they spend in jail, they're still required to complete treatment as it was ordered. So the ultimate goal is never incarceration. That's not what we're looking for. Although sometimes to motivate an individual, to get them to change their behavior and re-engage with treatment as ordered, that could become an issue. It's just not something that anyone's seeking to do unless it's absolutely necessary.